Our episode today is about employing workers from foreign countries. Evan, have you ever had any experience with family members or anyone that you know that's come in on a foreign visa?
Yeah, a little bit. My sister-in-law is actually from China. She immigrated here a few years ago, married my brother, and she's now a U.S. citizen. And her parents actually just came over. They got green cards on a, family type visa, and they just came here, and it was a really long process. I mean, it's taken years for folks to come over. So it's unlike a lot of the stuff we deal with. It's a very emotionally charged and very personal process going through the immigration process to get to the U.S. So that's a good segue to talk about today's topic, which is going to be business immigration with our partner, Robert Lee.
Okay, take a listen. Welcome to Hiring to Firing, the podcast. I'm Tracey Diamond, labor and employment attorney at Troutman Pepper, and I'm here with my partner and co-host, Evan Gibbs. Together, we tackle all employment issues from hiring to firing. Today, we've invited as a special guest, Robert Lee, who's our partner at Troutman Pepper and leads up Troutman's immigration practice. Nice to see you, Robert.
Hey, thanks for having me. Good to see y'all.
So, Robert, why don't you tell us a bit about the practice of immigration at Troutman Pepper and how you came to be an immigration lawyer?
So, the immigration practice here at Troutman is really focused on business immigration. So, U.S. companies who need high-level managers and executives or specialized technicians and engineers, that's the bulk of what our practice is. We have a very small part that's dedicated to family immigration. So spouses or children or parents seeking to bring their relatives into the U.S. But the vast majority is for business immigration.
I know our practices have a lot of synergies in that we come to you and your associate, Yane McKenzie, often with questions about immigration, both in the context of corporate deal work and also just sort of general immigration questions that our HR clients often have. And I thought it would be great to have you on today because we really haven't done a segment until now about employing workers from other countries. So that's our topic for today, the legal compliance issues associated with foreign workers. And to kick off this discussion, we're going to play a few clips from the 2009 movie. We're reaching kind of far back tonight, and it's called The Proposal, starring Sandra Bullock and Ryan Reynolds. Bullock plays Margaret Tata, a Canadian who works in the New York City book publishing company as its editor-in-chief. And in this first clip, Margaret learns from her boss that her visa renewal application has been denied. Let's take a listen.
Margaret, do you remember when we agreed that you wouldn't go to the Frankfurt Book Fair because you weren't allowed out of the country while your visa application was being processed?
Yes, I do.
And you went to Frankfurt?
Yes, I did. We were going to lose DeLillo to Viking, so really didn't have a choice, did I?
Well, it seems that the United States government doesn't care much who publishes Don DeLillo.
We just spoke to your immigration attorney.
Great. So we're all good? Everything good?
Margaret, your visa application has been denied.
That
And you are being deported.
Deported?
And apparently there was also some paperwork that you didn't fill out in time.
Come on. It's not like I'm even an immigrant. I'm from Canada, for Christ's sake. There's got to be something we can do.
We can reapply, but unfortunately, you have to leave the country for at least a year.
Okay. Okay, well that's not ideal, but I can manage everything from Toronto with video conferencing and internet.
Unfortunately, Margaret, if you're deported, you can't work for an American company.
Until this is resolved, I'm going to turn operations over to Bob Spaulding.
Bob Spaulding, the guy I just fired.
We need an editor-in-chief. He's the only person in the building who has enough experience.
You cannot be serious. I beg of
Margaret,
you. I beg.
We are desperate to have you stay. If there was any way at all that we could make this thing work, we'd be doing it.
There is no way. I am begging you.
No, Margaret, excuse me, we're in a meeting.
In real life, companies often hire workers who aren't U.S. citizens, particularly in specialized roles such as management and tech. And I think you were talking a little bit about that, Robert. So tell us, what types of visas are necessary to bring a worker from outside the country to work in the U.S.?
Sure. Well, there's the basis, I think, or the baseline for this part of the discussion is that an individual, a foreign national, can't just get their own work visa to come in and find a job later. Some countries, offer that, but the U.S. does not. So the U.S. basically requires a U.S. employer to sponsor an individual for a particular type of visa, a work authorized visa. So the more common ones, there's an alphabet soup of visas, of course. So the more common ones are the H-1B, which is for professionals with bachelor's degrees in a particular field. The L-1, which is for intercompany transferees, so multinational companies who need, as I mentioned earlier, a manager to oversee a certain part of their U.S. operations, or if someone has a rare technical background and they need them in the U.S. to do work here. There's also the O1, which is for extraordinary ability workers, so in science or business or the arts, for individuals who have reached the very top of their field. Then there's also treaty-based visas for the E1 and the E2 for nationals of a particular country who are coming in to work for companies that have either invested in the U.S. or do a requisite level of trade with the U.S. And then there's other treaty-based visas such as the TN, which is only for Canadian and Mexican nationals. And this was part of NAFTA, which is now the USMCA. But these are all they each have their own specific rules and requirements. And so the trick certainly is finding, for our clients, they'll have a particular need. And so we have to figure out how that need can be met through the existing rules for one of these visa classifications.
I have to say, I already have a whole bunch of questions that are swimming in my head. But first, I wanted to just ask a point of clarification. The L1 visa, when you talked about sort of intra-company transfers, and I'm not sure if I got that language correct.
No, that's right. Yeah.
Yeah. Does that apply when it's a parent and a subsidiary, or does it have to be the same company that happens to have offices in a foreign country and then also has offices here in the U.S.?
So no, the regulations are fairly broad with respect to the type of corporate relationship. So it could be the qualifying relationships as listed in the regulations are parent subsidiary, affiliates with a common parent, and a branch office. So if you have parent subsidiary, either the foreign company or the U.S. company can be the parent, either can be the subsidiary. When you're calculating or when you're evaluating those qualifying relationships, then the key question is ownership and control. So, obviously with large companies that have a complicated ownership structure, you could have a subsidiary, a U.S. company that has a joint venture or a subsidiary in Germany, but they only own, say, 3% of the German company, unless there's some other agreement that gives the U.S. entity control over that 3% subsidiary, then they're not going to qualify under these rules. So there has to be that common ownership and control component.
Interesting. Because for other reasons, I could see where the companies would want to keep themselves separate so they avoid some of the joint employment rules. Whereas for visa purposes, it looks like they want to keep themselves as together as possible.
Yes. Yeah, that's definitely true. And then so then they're competing interests, on one side of the table versus the other. So definitely.
I'm really curious about the extraordinary ability visa? And I'm wondering, how does somebody qualify for that? I mean, do they have to, be some kind of, savant or something like that? I'm just curious, what
The
the
superstar
qualifications
visa
are for that. Yeah.
Yeah. And that's a very apt way to put it. What we've seen is and the regulations list like 10 types of evidence, and the foreign national has to satisfy at least 3 of them. Or in the alternative, I have not had any of these types of cases yet, but if they have a Nobel Prize, then that's pretty much, I would think that it's automatic.
I would hope so.
Yes.
Yeah, seriously. The
I didn't
Einstein
win, but
visa.
I was a laureate. I didn't win. Oh, sorry.
Sorry, we don't want you here. Yeah,
No,
exactly.
no.
Yeah, use your genius elsewhere because we don't want that. No, it's if they don't have a Nobel Prize or some other internationally recognized award, then you look at these 10 criteria, and it can be, if they have a track record of publications in the research context, if there is press, in general press or in the industry press about them and their contributions to the field, if they've had a leading role in an organization, a respected organization in the field, if they've commanded a high salary is one of the criteria as well. And so we've done numerous O1 visas where it's in the research field. So they're folks who are researching particular material applications. And so they have a lengthy publication history. And then they have colleagues or other laureates, if you will, in the industry, recognizing or telling the story, if you will, about their contributions to the field. It can be very straightforward, for individuals who check all those boxes, and those can be approved very quickly. You have other folks who are less so, where it's the equivalent of my mom said I was really smart. Then I got my 10th grade paper, got an A plus. It's like no,
ribbon for participation.
Right? Yeah, exactly. It's like that's not quite what they're looking for. Those cases are fairly I don't know if enjoyable is the right term to work on, because you have to dig deep into their industry and what their accomplishments are. And if you have someone who's a world-renowned photographer, and so we dug into who they've worked with and their awards, and it was a fascinating case to work on. And even though it might not be obvious that this person is the extraordinary ability, when you dig into the evidence, you find that it actually does meet all the requirements, and so you give it a shot and it works out. So,
and I think this question probably varies by visa type, but how long does the process typically take?
So once the petition is filed with immigration, then for most of these, if not all of them, you can pay an extra filing fee to have it processed anywhere from, for these non-immigrant visas, then it's within 15 business days. That additional filing fee is $2,805 as of now.
And $5, it's the $5 that are going to have employers say, forget it.
Yeah, exactly. Yeah, I think that they landed on that. It used to be $2,500 until recently, and then I think they did an inflation adjustment, and so that's where they got that extra $305. In all seriousness, like the filing fees can add up, and it can often be a barrier to getting either that premium processing done. If you can't come up with that 2,805, then these things can sometimes take anywhere from 3, 6, 7, 8, 9 months. For the clients who can afford it, it's obviously a tremendous help to them to get these individuals into the U.S.
How long do these types of visas that you discussed, I'm assuming they're all temporary, and I'm curious how long they last. How long does it grant the person the right to work in the U.S.?
Yeah. So for most of these, we're talking about the H and the L, the TN and the O1, those are all, for the most part, you have 3 years of initial eligibility, and then those can be renewed depending on the classification. So for the TNs, there's no ceiling as to how many times somebody can renew that visa, but they do have to show the intent to return abroad. So we've had clients who have held a TN for 12, 15 years, but they're still able to show that they have family still in Canada, or they maintain their residence and own a separate business in Mexico, or whatever the situation is. For the H-1B, again, there's an initial 3-year eligibility, and then they can renew it for another 3 years, unless if their employer or if they get sponsored for a green card for employment-based permanent residence, and if they are able to get to a certain point before the end of that 6 years of initial eligibility, then they can renew their H-1 status indefinitely. So the times vary. For the L1, the managers, they get ultimately 7 years of initial eligibility, 3 years initially, then 2-year extensions. And for the specialized knowledge workers under the L1, the L1B classification, then they get 1 2-year extension, or 5 years total.
So I often hear about employers having employees come in on an H-1B. Actually, my initial question is is there one visa that you tend to see more of with your typical non-Nobel Prize winner employee versus another, or do they really run the gamut of sort of the major four? It sounds like the big four, H-1B, L1, O, and TN.
Yeah. So the H-1 is going to be the highest volume, I guess.
That's what I figured.
Yeah. It's limited in the sense that the government only gives out a limited number of new H-1s every year. right? So once somebody has an H1, then they can transfer that to other employers. The other employer has to file the petition to transfer and all that, but they only give out a limited number of new H1s every year. This year, I think they did the lottery for it. There were something like 400,000 registrants for the H1 lottery for a total of 85,000 available visas. Last year it was upwards of, I think, 700,000 or 800,000 submissions. They changed the rules a bit to combat fraud, and there were certainly some issues with respect to how the lottery was previously done. I think this year these are definitely improvements, these changes for the better. So, but it's still, the odds are still incredibly slim for these folks.
That's crazy. I often hear about you have an employee here on an H-1B and the employer decides they want to terminate. How does that impact the employee with the H-1B visa?
Yeah, that's a great question. So the employee's immigration status, their ability to lawfully remain in the U.S. is tied to that employment for someone who's in H-1B status. So if they are terminated or their employment ends, and some folks quit or resign without understanding the impact on their immigration status. But so as of the date that they are let go, or as of the date their employment ends, then technically speaking, they're no longer maintaining valid H1 status. There was a recent change in the regulations. I say recent, but it's 6 or 7 years now, but where the regulations codified an eligibility for a 60-day grace period after that termination. So for someone in H1, if they are laid off, say April 1st, then they have the next 60 days to either find a new sponsor who can file the H1 transfer for them, or file another change of status to change status to tourist visa, or try and become a student. But if that paperwork, if that application or that transfer petition is filed within those 60 days, then the fact that they lost their job previously, that doesn't count against them. But if it's, say, 65 days or any time after 60 days, they can't rely on that codified 60-day grace period. But depending on the circumstances, they can still ask for discretionary approval of that. But it becomes a lot harder if they get, if they're beyond that 60 days.
I think this is a good segue to talk about the movie again. And in the movie, one of the reasons that Margaret's visa renewal application was denied was because she left the country to go on a business trip in Germany. In reality, Robert, are there any limitations on an individual's ability to travel outside the country if they're here on a work visa?
Yeah, so in limited circumstances, I think that there's now probably a good time to talk about the distinction between visa and status. So in the movie, when they talk about her extension or her visa application pending and then it having been denied, then that's not really, the term is being used a little loosely. So in order for the visa is the attachment in the passport that allows someone to enter the U.S. And then once they are in the U.S., then they have that visa status. So ordinarily, when somebody comes in on an H1, for example, then there would be an H1B stamp in their passport to say that they can come in H1 status. If they change their status in the U.S. or if their extension is pending, then that's when the travel restrictions come into play. Because if you have someone, for example, if someone graduates as an F1 student, they are selected in the H1 lottery, and then their employer files the change of status to H1. If they leave while that change of status is pending, then that request to change status is abandoned, essentially. And so they might be able to come back in on the F1 visa, re-enter the US on F1, but their H1, their status won't change automatically when that H1 petition gets approved. So those are the types of restrictions. And I was trying to figure out in the context of the movie, like why her leaving the US would have that impact, especially if she was readmitted anyway. And the only thing that I could think of is she held a status like an H1, for example. They filed to extend her H1 status. And in the meantime, her underlying H1 status had expired. And so using that same example, let's say if her H1 status expired on April 1st, and they filed her extension prior to April 1st, then that's fine. Like, it doesn't have to be approved before her status expires. So having that pending extension allows her to remain in the US and continue working. But if she departs the US after her underlying status expired, and even if the extension is still pending, once she leaves, then that preservation of her authorized stay and work authorization, that goes away. So if she had departed the US while that extension was pending, and ordinarily if she, as a Canadian, she's not required to actually have a visa stamp in her passport. So in the context of the movie, again, I think she went to Frankfurt, and when she came back in, she just showed her Canadian passport and she was admitted as a tourist or as a visitor. And when that happened, then once she went back to her office or when she started working again, then she was violating her immigration status because she was now a visitor and not an H-1B visa holder.
I love, Robert, that you've given that much thought. I really think that the reason why they said she, no longer legal in the U.S. because of Frankfurt was just sort of a construct so that she could have a relationship with Ryan Reynolds. In the movie, Margaret attempts to solve her visa problem by blackmailing her assistant, played by Ryan Reynolds, into marrying her. And that leads to this big exotic trip to Alaska where Ryan Reynolds' family lives and a potential wedding. And then she kind of comes clean in the end. And they all live happily ever after when Ryan Reynolds says, "Yes, I will marry you because I want to date you." So let's listen to a clip.
Let me explain to you the process that's about to unfold. Step one will be a scheduled interview. I'll put you each in a room, and I'll ask you every little question that a real couple would know about each other. Step two, I dig deeper. I look at your phone records. I talk to your neighbors. I interview your coworkers. If your answers don't match up at every point, you will be deported indefinitely, and you, young man, will have committed a felony, punishable by a fine of $250,000 and a stay of 5 years in federal prison. So, Andrew, you wanna talk to me?
So in real life, what are the rules on marriage and citizenship in the U.S.?
So in real life, they don't let you storm into the USCIS building and talk to an officer. So the main thing, I think, in terms of a marriage-based filing is that the marriage has to be, quote unquote, bona fide. And that's defined as it wasn't entered into get around the immigration regulations, right? So the movie's absolutely right in terms of like the harsh penalties for immigration fraud. So when the way the process works is that they would first have to get married, and then the U.S. citizen spouse would file an immigrant petition for, in this case, for his wife. And that process, it's been taking a while now, but it's certainly not immediate. It can take upwards of a year, perhaps. When you file that petition, then you include the marriage certificate, of course, and the evidence of the bona fides of the marriage. There are things like what we include are copies of the driver's licenses to show that you live at the same address, whether it's a lease or a mortgage. That you share bank accounts and credit cards, so you're listing each other as the beneficiary of your life insurance, or you're all on the same insurance. You have children together. You're both listed on the birth certificates. All those things are what the government looks at when evaluating a marriage-based petition. Pictures from the wedding, you can talk about things like that, or including here are the itineraries, the 5 trips we took together, when we traveled the world or what have you. So there isn't an immediate benefit, just by getting married. She certainly wouldn't be able to immediately start working again. It doesn't fix all those problems. She would still need to wait for the company to be protected, right? Getting it back to the I-9, she couldn't just say, "Hey, I'm married to a U.S. citizen now, give me my job back," right? They would still need to go through the I-9 and all that to re-verify her. Anyway, so it can take quite a while, but those are the main concerns. And to the movie's credit, I guess, if the officer does suspect fraud, then they can have those separate interviews and ask the same questions or ask different questions. When was the last time your parents visited? What's your brother's middle name? Or things like that. That they can ask about.
Or fly to Sitka, Alaska, and make sure you're there for the wedding.
Yes. I don't think that they do that.
That would be a little bit of a stretch of government monies. Yeah.
What are the consequences for an employer, for a company, if they employ someone illegally?
If it's an innocent mistake, for example, it can vary. Basically, it can vary from a small, relatively small, few $100 fine, up to, if there's a pattern of practice of knowingly employing unauthorized workers, then that can be thousands of dollars in fines and potential criminal liability and jail for the employees of the company that are running the scheme, so to speak. I think that the circumstances would have to be pretty egregious, which in order to lead to the jail time. But it certainly is possible. It certainly can and does happen. So I'll leave it at that.
So another aspect of workplace immigration law I know that you deal with a lot, Robert, is I-9 compliance. And I know this comes up in the context of advice and counseling and also in the context of corporate deals. Are there any particular issues that employers should be looking out for in making sure that their I-9 process is compliant?
Yeah. So the baseline concerns about the I-9, right? It's basically a 2-page form now. But the guidebook, what the employers need to know is in what's called the M274 handbook, and that's 150 pages long, right? So it's not as simple as the form itself would indicate. The main concerns for I-9 compliance are the first thing is the timing, because you can't fix it if it's not done timely. The employee has to complete their section on the first day, at the time of hire, by the time they start working for pay. And then the employer has to complete their portion, to review the documentation within 3 business days of the date the employment begins. If it happens on the 4th day, that's too bad, and you kind of have to accept that. You can't really fix that. Unlike if there's a date was or an address was misspelled or something like that, then those can be corrected. But the fact that it was completed late, that can't be.
You can't go back in time. Yeah, you can only go forward. You can't go backwards.
That's a different movie. Yeah, exactly. So another concern is employers, getting their arms around the remote worker circumstances. So, obviously, after we left the pandemic, we realized that people can work productively remotely. Then you might have a business that hires someone 10 states away. And so during the pandemic, there were some accommodations made for the I-9 verification, but now those went away unless you're registered with E-Verify, which is a separate thing. But for the purposes of this discussion, if you're a company that hires a remote worker, you still have to have those, you still have to meet those timeline requirements. So what the guidance suggests is that, if they're working remotely from their parents' house in 10 states away, then authorize one of their parents to review their documents. It doesn't have to be an employee of the company. It just has to be somebody authorized, a competent adult authorized to review the document. That's a good way. It could be a college roommate. It could be the barista where they're working at the coffee shop. Whatever the case may be, as long as it's a competent adult that they can physically review the hard copies of the worker's employment authorization paperwork.
And I would just add to that employers should be careful not to go dig too deep, right? They should be looking to make sure it's reasonable, that the documents look reasonably legitimate, but they shouldn't be doing an independent investigation, or they may wind up with a national origin discrimination lawsuit.
Yes, that's absolutely right. There's certainly that concern when they start asking more questions. If there's an employment authorization card, well, no, you said you're not a citizen. We need to see your green card. It's not required. It's not required to have a green card to work. So when the employers start unnecessarily asking those questions or requiring specific forms of documentation, that's a recipe for trouble. So just stick to, here's what's required. They have this document or they don't. If it's reasonably related to the worker, then that's all that the employer really needs to do.
All right. Well, I think this is a really good stopping place for us. I want to thank you so much for joining us today, Robert. This was chock full of information. I know that'll be very helpful to our clients out there. Thank you all for listening. Don't forget to check out our blog, hiringtofiring.law, and our other podcast episodes. And shoot us an email. Tell us what you think. Give us some suggestions. We'd love to hear from you. Thanks so much.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.